Well, good morning, everyone, and welcome to the Compliance Officers Conference 2019. Now, despite the microphone, I am not clearly Madonna. I'm Clive Myrie, and yes, they couldn't find anyone cheaper, so I'm back. It is hard to believe that in my opening remarks last year, I thanked you all so much for rescuing me, for one day at least, from having to report on the interminable news of Brexit, as I'm here, instead, in Birmingham. That was 2018. 1 year on, I'd like to thank you all again for rescuing me for one day, at least, from having to report on the interminable news of Brexit, as I'm instead here in Birmingham. And make no mistake, despite Santa's sack being full of polling cards instead of toys this year, I'll be saying the very same thing next year. You don't have to be Madonna or Mystic Meg to know that. Seriously, it is great to be here again, and with a different roll of the dice many moons ago. I actually could have been sitting where you all are sitting today, out there in the marketplace stands or asking questions in one of our breakout sessions. We want to hear your views and answer your queries. And one way you can do that, one way you can interact, is through our conference app. Details of how to download it are in the program, as well as extra bits of information like speaker biographies. It'll also allow you to ask questions in our later session on money laundering. Now you can vote in polls, give feedback, and even sign up to network with other delegates here today. And here is a brief video with all its main features. There you go, ladies and gentlemen. Pretty simple, pretty straightforward. Hopefully some of you have already downloaded the app, and to give you a chance to try it out, we thought we'd give you a little test. Let's hope you all pass. Who is your favorite BBC News presenter? I told you it would be simple. Thank you. Is it A, some bloke called Clive Madonna Myrie? B, Fiona Bruce? C, Hugh Edwards? D, Nagamunchetti? Or E, Clive Myrie? Now, no pressure, ladies and gentlemen, but do feel at liberty to vote for options A and D. And while you're doing that, I wanted to highlight a few final points for today's conference. Now, you should all be able to access the venue Wi-Fi. You need to join ICC free Wi-Fi. Please do get involved on social media. All you Twitterers out there, we do have a Twitter hashtag, which again is this year, hashtag COLPCOFA, C-O-L-P-C-O-F-A. And finally, we aren't expecting any fire alarms or stage invasions. Do feel free to join me on stage if you fancy it, but I'd rather you didn't. If they should sound, the fire alarms that is, please make your way out by the nearest fire exit and follow instructions from ICC staff. So the housekeeping out of the way. I will, of course, share the results of the vote a little later on, but now, please welcome to the stage the Chair of the Solicitors Regulation Authority, Anna Bradley.
Thanks very much, Clive. I was just thinking, I wonder what the collective noun for such an enormous number of compliance officers are. I was in Australia a couple of weeks ago, and I saw a huge group of kangaroos, so I asked what the collective noun for kangaroos was. Apparently it's a mob. So I don't think we've got a mob here. Perhaps we should open a book on what the right term is. Anyway, good morning, everyone. Delighted to see you here for what is our 7th annual Compliance Officer Conference, and my first as chair, although I have to say I've heard a lot about them. And I understand that this year we've got a record number of attendees, growing every year. So whether you've been to every one or this is your first time, thank you very much for coming and a very warm welcome. I hope you enjoy the day. Please do get involved. That's the whole point, not just to listen, but also to contribute. We would really want to know what you think. So I'm going to try and set the scene for the future before we move to the immediate present and what will happen during the course of the next year. Because so since becoming chair at the start of the year, it's become really clear to me that the SRA has come a very long way since I first heard about it. They've built a robust regulatory regime for solicitors and law firms in England and Wales. They've developed a mature approach to working in the public interest, established an identity, and are now setting the foundations for the future. And I can say this because I was absolutely no part of it, but I have to say, as an incoming chair, I have found what I think is a very strong organisation, and I very much hope you all agree. I'm sure you'll tell us if you don't. So over the last few years, we've been very focused on increasing competition while, very importantly, maintaining appropriate protections for consumers. And a key aim of our work has been to allow law firms and solicitors to better meet the expectations of consumers and, of course, of wider society. And we think that will mean that there is an increase in access to high-quality, affordable legal services. And that's really critical because, as I hope you all know, only 1 in 10 people is using a regulated lawyer when they have a legal problem. And when small businesses are more likely to ask their accountant for help with a legal problem than a solicitor. So we know there's something quite wrong here. So in the last year, we finalised the work that was foreseen in our last corporate strategy, work that we've been doing to refocus regulation on what really matters, the high professional standards that underpin public confidence. And you're going to be hearing a lot more about this today because there's an imminent implementation date coming up, as I'm sure you all know. We've also just begun, in fact, discussed at our last board meeting, the process of evaluating our reforms to check that they are actually doing what we wanted them to do. But all of that means that this is a really good time to be thinking about the future and what we need to do to be prepared for it. And that's what I want to focus on for the next few minutes. The first thing that's clear is the context is one of much change. There is considerable social, economic, political and environmental change and indeed uncertainty, which will bring new challenges to the rule of law and access to justice. And really importantly for our sector, technology is set to transform the way solicitors and firms work and how legal services are delivered. Just look at the pace of change in financial services over the last few years. We're going to see that happen to us sometime soon. And consumer expectations have also developed with high service standards which have been established in digital environments. And consumers don't make a difference what they get from all of the digital retail sites they expect to get from other service providers. And they also have an expectation that appropriate protection will be available no matter who delivers it, and they don't really mind who delivers it, they just expect it to be there. So we recognise that our future strategy will be set in the context of very significant uncertainty. And if you needed any evidence of that, as Clive has already said, it's right in front of us, because who would have thought that today, on the 30th of October, just before we're supposed to leave Brexit again, leave Europe again, that actually we're talking about election, not Brexit. Pretty difficult to predict, and that's the nature of our world. So our new corporate strategy, I want to give you a little pen portrait of. We published a draft earlier this month. It will begin from the end of next year, so 2020 to 23. And it describes our ambition as being, wanting to be a progressive and relevant regulator that is able to anticipate and respond with agility to emerging opportunities and challenges. And that's all to do with this uncertainty that sits around us. We can't set ourselves on a path and just stick with it with our noses down. We need to be very alert to what's going on around us. And we've set out 3 key aims for our strategy. The first is, if you like, more of the same, setting and maintaining high professional standards for solicitors and firms as the public expect, and ensuring that we provide an equally high level of operational service to everyone who interacts with the SRA. The second is about actively supporting the adoption of legal technology and other innovation. So not just waiting for it to happen, but being more proactive than that. And the third is about building our understanding of emerging opportunities and indeed challenges, the horizon that is coming to face us as we think about the legal sector. And perhaps it should go without saying, but I will say it, that access to justice is woven through all of those proposed objectives, a bit like Brighton through that stick of proverbial rock. And in all of our work, we think we need to reach out to others more and collaborate. And that's really because there are many difficult issues which we are facing for which we do not have all the solutions. There are many such difficult issues that cover multiple sectors, such as, indeed, access to justice, but also things like leasehold arrangements, investment scams, and money laundering. In all of those areas, there are other organisations that have to come to the party and help to solve the issues. So, let me explain a little bit about our thinking on these 3 aims. First, professional standards. Well, our strategy must start from solid foundations, making sure we deliver on the day job, including checking that the changes we're making are delivering what was expected. So by 2023, I expect us to be seeing our consumer information work, the new standards and regulations, and the enforcement strategy all properly embedded. And the solicitor's qualifying examination, we hope, will also be beginning to make a difference. And we will be measuring progress on all of those things at 1, 3, and 5 years to give account of the impact that our work has had. I also want us to do better ourselves. Everyone who uses our services must have an excellent experience. And of course, we must do that and still deliver value for money. So that means having efficient and effective processes and being really transparent about why we're doing what we're doing and how much it costs. And as I've said, we will work with others, so learning from the best and from those who use our services so we can improve them. Our second new objective is about supporting legal technology and innovation. And we think innovation, including, but not limited to technology, presents an absolutely huge opportunity to deliver legal services in new ways that will better meet the needs of more users. Smart services, delivered straight to the people who need them, could provide more affordable legal advice and support. And tech can also, of course, be used to reduce firm costs and overheads, and that, in turn, should produce savings that could be passed on. We've already developed our work in this arena, so just to remind you, our SRA Innovate programme was set up around 4 years ago, offering a safe space, we've called it, which allows firms to test ideas to see how they work, while we can also test the regulation and make sure that consumers will still be protected. We've been actively encouraging change using technology, beyond our innovation work, and a key part of that is our Legal Access Challenge, funded by the UK government's Regulators Pioneer Fund. We had nearly 120 applications from a very wide range of applicants, which were of fantastically high quality, and frankly, as chair of the judges, we had a really hard time to decide on 8 winners. But we announced them last month, and there are some really exciting proposals in there, including projects which seek to help people with learning disabilities access legal advice, to provide support on employment law, and another which is looking to help small businesses with online dispute resolution. But there are many, many others. They're all ideas that have the potential to really change things for the better, and that's what we want to see more of. So we're already learning from the challenge and looking at what more we can do. And one of the things we want to do is to build the network that is evolving between tech providers, experts in the provision of legal services, and investors. Investors are a really important part of this picture, such that the right people can get in the room and solve problems which we can all see. But going forward, we want to be even more active in supporting the development and responsible adoption of legal technology, and that means building our own capability and working closely with solicitors and law firms, all of you in the room, on innovative approaches to offering services. Finally, our third new objective is about understanding emerging opportunities and challenges. As I've said, fast-changing world, and we all, that's you and us, need to be on the front foot. We need to look ahead and find new ways of working with other organisations to best serve the public. So by the end of our next corporate plan in 2023, I want the SRA to have a much deeper understanding of emerging opportunities and challenges for consumers, for the legal sector, and for regulation. We should be in a much better position, I hope, to anticipate emerging risks, and should have established the sort of effective partnerships with others that will allow us to respond. And I hope that that also will mean that we are better able, from a strong evidence base, to make appropriate contributions to those policy debates around regulation, access to legal services, and wider consumer protection legislation. But the reason why I'm talking about all of this is because we want to know what you think. It's a consultation. It's out there until late January, and so I want to encourage you to please take a look, let us know whether you think we're focusing on the right sort of activity, either through the consultation on the website, or if you want a quick way to input, there's a short survey available on the SRA marketplace stands here today. Or, of course, you can come and speak to me or any of our SRA colleagues here today. I'll be here all day, and I'd love to hear your thoughts. That's about the future, though. And I know what you really want to hear about is what's going to be on your desks in the next year. So for the rest of the day, we're going to focus on much more immediate changes coming over the next few months. But I hope that kind of sense of direction about where we're planning to move will serve as a useful backdrop. So thank you. I very much hope you enjoy the day.
Anna, thank you very much indeed for that. Now, let's hear from the SRA's Chief Executive, Paul Phillip. And I'd also like to invite onto the stage to give their thoughts on what you need to know about the SRA's regulatory reforms coming into force later next month, Juliet Oliver, Executive Director, SRA, Jane Malcolm, Executive Director, External and Corporate Affairs, SRA, and Juliet Brennan, Director of Education and Training at the SRA. Come to the stage.
Wow. Good morning, everyone. It's good to see so many people here today. When we came in here this morning, the place was a bit chilly and looking a little bit empty. It certainly warmed up a bit, and actually It's looking very full. I usually start this, because obviously I've been at a few of these, hopefully you have too, by saying that we started this little shindig off, I think it was in 2013, so it would have been a year just before I joined the organisation, with about 200 people in a shed somewhere. And here we are today at the ICC in Birmingham with over 1,600 delegates registered for the event. We have some people who couldn't make it on the day. But the exponential growth in this conference, I think, recognises the fact that there's something to talk about and something worth taking time out of your day-to-day. And we are very grateful for that and look forward to having those side conversations that are so important in events like this, that hopefully make it worth your while coming. I'm going to talk about the present, about what's been happening in the last couple of years and what's going to be happening next year. There are three of my colleagues to my left who will be talking in detail about some of those proposals, and there are plenty of opportunities throughout the day, various side discussions about some of the really important issues that we think you need to know about going forward. I just wanted to touch on something really that Anna said. So we've got a new corporate strategy. We're out to consultation. And I agree with her. I think we're an organisation that's evolving, and actually we're doing reasonably well. But one of the areas that I do think, and I have to take a little bit of responsibility for this, that we're not doing as well as we could is in relation to innovation, and in particular in relation to technological innovation, which is why we're putting that focus on our work going forward. And I was, like most people, I get most of my news by news app these days, and I am actually interested in AI and all things computing, so I can tailor it and you get lots of stuff. And I was chuckling when Anna was mentioning innovation and technology, because there was an item that came through on my news feed the other week where there was a professor of AI at a well-known California university in Silicon Valley who was on the internet looking for love, and he thought he found it with a young Russian woman who he had been emailing with for about 2 months, until he thought one day, well, hang on a bit, and he typed in a load of gobbledygook into the keyboard, and lo and behold, he found out he's been speaking to a chat bot for the last 2 months, which was all the more ironic given his eminence in the field. So I think people were commenting that it might be the first example of Turing's law, the idea that within 50 years, this was propounded in the 1950s, we would actually be deceived by a computer to believing that it was actually human. And that type of thing is a good example of where AI is taking us. It will impact on everything we do in the world going forward, and therefore to suggest that legal services will be immune to that would be somewhat illogical and naive. And therefore I do think we need to understand how innovation and technology impacts on present market participants, such as yourselves, how it impacts on people accessing legal advice, presumably more and more online, and what does the hinterland of AI mean for the profession? What does it mean for the regulator? Does it make us redundant? And generally speaking, what it means for the public. So I think this is a really important issue in terms of going forward. But just coming back to the present, as I say, we have lots of interesting and quite challenging stuff to talk to you about today. There's been a few things going on throughout the year, and it's been the culmination of a policy programme that, from our perspective, has taken about 4, possibly 5 years. As I say, we have 3 subject matter experts, which we'll return to in a second. What I wanted to talk about, really, for the next 10 minutes or so, is the why. Why are we doing this? What is the rationale? Why make these changes? And then my colleagues will talk to you about what those changes actually are. And I think I'd like to start with a proposition. And the proposition is that ideologically, for the most part, I think the SRE as a regulator, and most, if not all of you, are on the same page. We want, essentially, with perhaps one exception that I'm going to talk about, we want exactly the same thing. We want the profession to be held in high regard. We want the public and society as a whole to trust and exude high levels of confidence in solicitors. We want solicitors to do a good job, do the best for their clients, uphold the rule of law, and maintain high professional standards. I think I would guess that most of you would sign up to that. Where it gets interesting is how do you achieve that? How do you police that? How do you ensure that actually that is what you get as an outcome? And there are two main drivers, I think, in relation to the changes that you will hear about today, and most importantly, the changes to our standards and regulations that we're about to introduce on the 25th of November next month, tomorrow. And the first is a fairly straightforward implementation of what has become known in the trade as better regulation principles. What should a regulator do? All regulators that I'm aware of sign up to some extent with these principles, and they are things like transparency, consistency, proportionality in your regulatory model, a risk-based targeted approach, focusing your resources on where the risks are greatest to those you regulate for, and in our case that is the public, the wider public interest. So for us it's about getting that Goldilocks zone between it's not too bureaucratic, it's not too costly, it's not too burdensome, it's not too protectionist for present market participants, but yet it has the checks and balances that are necessary to protect the users of legal services and things like upholding the rule of law as a principle sufficiently. And that's what we're trying to do. Essentially, time will tell whether or not we've addressed it, but on the 25th of November next month, we will be abolishing the SRA handbook and introducing our new standards and regulations. It's about liberalisation, if I can say that, of the marketplace. It's a move to a more principled approach rather than a compliance approach. It's less rules, it's less bureaucracy. We're moving from a rule book that has over 400 pages to one of 130 pages or thereabouts. About 2 years ago, one of the staff at the SRA found the Code of Conduct for Solicitors that was produced by the Law Society about 25 years ago. It was just the version at the time. I think it was about 14 pages long. And, you know, at the moment, our code of conduct is not much longer than that, and as you'll hear in a minute, we're having two moving forward, one for firms and one for solicitors. But how did we end up in a position where we ended up with a handbook that was 400 pages long, and if you include various appendices, etc., much longer than that? Our view is it's far too much bureaucracy, it's far too many rules, and that's why we're moving to culling it. So that's what STARS is about. That was the driver behind it. It's about becoming a proportionate regulator with a proportionate model that adequately protects the public and allows solicitors to practice in a less burdensome, less costly way. And that's where I think the agreement completely finishes, and we have a little bit of contention. Because we are a public interest regulator. Our primary interest is in protecting the public and making sure that standards are high in the practice of law as a solicitor. And the second driver for change is something that's been quite contentious. And about 5 years ago, the board of the SRA focused in on the whole idea of it's not really good enough to reduce burden, bureaucracy, regulation, and also cost, but not to allow that to be passed on to the users of legal services. And therefore, we looked at the idea of competition and freeing up markets. It's clearly one of the priorities identified in the Legal Services Act. And we started looking at how that could happen and how we could do something, make a contribution to that. And in the middle of doing all that, the CMA came along, so the Competition Markets Authority produced their investigation and their initial investigation into the legal services marketplace in December 2016, so approaching 3 years ago. And they are saying that they will come back probably next year to have a look at the marketplace again. And there was a bit of what they were suggesting in our discussions with what we were proposing that chimed. And that bit was what I think has become known as freelancers. We don't particularly like the term, but it's got momentum, so we ran with it. The idea that a solicitor for the first time could practice as a properly trained and properly regulated solicitor outside of an authorised law firm, doing reserved or non-reserved activities, but with certain safeguards around about not holding client money, not employing staff and that type of thing. And actually, we've gone with that, and that's a key component of our standards and regulation changes. The CMA said that the market was not working well, and actually that, in relation to our changes, is probably our contribution to that. And at the time in the report, the CMA endorsed that as a way forward. And we will be introducing that in something like 3.5 weeks' time. It's about reducing the cost of regulation. It's about greater access to solicitors by the public. It's about lower cost to consumers. And it's about greater opportunities for areas of practice for young solicitors coming into the profession. Time will tell whether or not this has, on the whole, been a good thing. We think it will be. It's certainly one of the most contentious things we've been doing in the last few years. And we're on the cusp of introducing it. If you are not familiar with that particular development, I do encourage you to look at our website and see whether or not it has anything interesting or anything opportunistically to offer you as a business or as a business model going forward. The second thing I'd like to talk about this morning is the solicitor's qualifying examination. And perhaps to just go back a bit, because the genesis of all this was in something called a Legal Education and Training Review. I know about this because I just published at the time at which I started in the job I have now. It was a joint review sponsored by the SRA, the Bar Standards Board and Silex Regulation, and it was an attempt to look at legal education and training and put forward best practice as to how we can make sure that the right people enter the profession with the right sorts of training and preparation. And since then, we've done quite a lot in education. We looked at CPD, and we reduced, matter of fact, we completely removed the idea of collecting points to achieve continuous professional development, whilst at the same time acknowledging that it's a really important professional principle for each and every solicitor. We, for the first time ever, set out what we see are the core competencies of being a solicitor, and now we're moving on to looking at how this would be assessed at the point of entry. And there are some problems with the present arrangement, and in many ways, actually, this is what one might call a back to the future initiative. So actually, from our point of view, just to quickly say what it is, it's an independent assessment of suitability. It's a national licensing examination, a bit like the TLS finals, the Law Society finals of yesteryear, for those of you who set those, where those who assess suitability are not the same people who do the pre-assessment education, where there is a perverse incentive towards grade inflation and looking to recruiting your next cohort of students, and where there's inconsistency between institutions that run these courses, and actually an unacceptable inconsistency. So what we are trying to do is deliver an arrangement that delivers high professional standards at the point of entry. It's about delivering consistency. It's about levelling up the playing field, regardless of whether you've had an advantaged or less advantaged background as a young person. It's about removing prescribed pathways to the profession, and it's about ensuring that everyone who sits the assessment, regardless of the mode at which you take, whether you sit a traditional law degree or you do a non-law degree and a type of GDL type of arrangement, whether you follow a Silex modular approach or whether or not you do an apprenticeship, you will all sit the same examination, the same test at the end of that. And if you can perform, then it really doesn't matter in relation to the quality of the university that you may or may not have gone to. You'll be able to demonstrate that you are someone of quality and therefore deserving of a place in the profession. So I'm going to leave it there. I'm sure Julie will pick up on some of those issues. The other issue I wanted to quickly touch on is the issue of transparency. And, I've already mentioned the CMA. The CMA says the market really wasn't working well for consumers at all. And has already mentioned that our own research suggests that 9 out of 10 people, when they have a legal problem, if they identify it as a legal problem at all, don't go and see a properly trained and properly regulated lawyer, predominantly a solicitor. Why is that? Well, our research would suggest that price is a big deal. Not so much that you're too expensive, it's just that people perceive that you're too expensive and that they're not too sure how much you're going to cost in any event eventually. They also find solicitors a bit unapproachable, a bit stuffy, not looking like they do. And, you know, from any business perspective, is the type of thing I think you need to take heed of. Jane will touch on those issues in terms of what we are doing about obliging people to publish price information, publish complaints information, looking to publish signposting to people like the Ombudsman. But just to leave you on that little one with a personal anecdote, about 2 months ago, I was actually speaking to Anna about it. My wife and I decided we were going to renew our wills. So fairly straightforward. I don't have any business interests. I'm a wage slave for a living. We own a property as a joint tenant. We want a mirrored will, very straightforward. So I decided I would type out an email to 5 or 6 local firms where I live and ask them for a quote in relation to providing the will service. And so I got 4 or 5 quotes back. I think one person decided not to respond at all. It went from about £3,500, which was £350, I thought was reasonable, to £7,500. Now, I don't know who signed that email, but they really someone ought to have a word with them, because it's no way to encourage people to use your services. I eventually went with a well-known online provider. It went very well, and it was £299. But I suppose the anecdote is, as the chief executive of the SRA, when faced with, well, I want to make a will. I know I could probably do it myself out of W.H. Smith or something, but actually it's really important. I'm going to think about using a proper lawyer, and for my money, that's a solicitor. So how do I go about picking a solicitor that's any good? Well, one of them is how much they cost, but it's not the only thing by far. But I have no other way of deciding who's any better at writing a will than any other member of the public. Matter of fact, one might argue I should be better placed, but that's proven not to be the case. So, very quickly then, before I finish, what else has happened during the year? Well, you know, some lowlights might be the old sex, drugs and rock and roll thing. So we've had a little bit of outing in that in our disciplinary work. Specifically, inappropriate sexual conduct by solicitors, either inside or outside the workplace. Some say, and it has been said in the legal press, that the regulator should be getting involved in this type of thing. I beg to differ. The fact is that for the most part, what we are actually talking about is breaches of our code, either an abuse of a position of authority or a complete and utter lack of integrity, and we will always take action where we find that type of thing. And I suspect, given the change in societal expectations around about this, you will see more of that in the coming months and years. Questionable investment schemes is another theme, which is where solicitors, on the face of it, appear to be fronting questionable investments down to the point of, you know, complete Ponzi schemes, and allowing their client account to be used where there's no underlying legal transaction. That's the kind of thing that's not only dishonest, but it's the type of thing that destroys your reputation and needs to be stamped on quickly, and we will do that. Problems with social media, so solicitors identifying themselves as solicitors and saying and doing things on social media which you might argue is unbecoming of a member of the profession, and most definitely impacts on confidence, trust, and the standing of the profession generally. And lastly, for me, and by no means least, an issue that you hear a lot about today, which is the issue of anti-money laundering. Someone said to me at a meeting the other day, isn't this all coming from Europe, and aren't we kind of leaving Europe, and therefore maybe we don't need to do all this kind of thing? And, you know, we need to do it. It's a major priority. It's morally wrong. It's not a victimless crime. And in any event, we need to do it all the more because we're leaving Europe, because no one will do business with us as a country if we don't comply with these types of things. So you have seen in the press our pronouncements on this in the last few days. We have an active programme. We have a new director of anti-money laundering who will no doubt be in the hall, Colette Best, and you'll hear from her later on today. And over the next 6 months, we will be becoming much, much more active in terms of proactively visiting firms who we deem as high risk in this area. We've already called in over 400 AML risk assessments. You have seen in the press that many of those are wanting, and we will need to follow those up. And then in the next few weeks, I will be writing to all senior partners of firms who do high-risk work, asking them to confirm their compliance with anti-money laundering rules, regulations and legislation. And the 6,500 firms who do high-risk work predominantly do conveyancing or trust and company services work. And therefore, if you own one of those firms, you will be receiving a letter from me asking really just to confirm and provide a focus on this really, really important area. Not just of our work, but of your work. It's important for us, it's important for solicitors, it's important for society. And you will see us putting a much greater emphasis on that going forward. There will be many, many more prosecutions in relation to AML, and you will see the SRA gearing up to make sure that this important issue is dealt with appropriately by the SRA and by the profession. So that's really all I had to say today. I just wanted to say I hope you enjoy the day. There is an awful lot of good stuff here. There's an awful lot of good people here, both within the audience and at the SRA, that are worthwhile speaking to in relation to the detail of all this. But thank you very much for listening, and I think I'm due to hand over to Juliet Oliver. So Juliet is the General Counsel of the Solicitors Regulation Authority, and she's going to talk about our standards and regulations.